Everybody. Kindly, my lord, to mention, my lord, this matter, my lord, for application of review. My lord, the Lordship's order, my lord, passed on 1st of April 2026. My lord, Lordship has granted, my lord, the retired employees to, my lord, to approach, my lord, other remedies, my lord, whereas, my lord, the records will show, my lord, that these issues have already been decided. My lord, this arises out of the contempt application. Contempt of this honorable court, my lord, that implementation of the order passed in the writ petition was not done, against which a contempt was filed. And, my lord, in the contempt application, my lord, the government authorities, my lord,
seeking review of what?
well, review of your lordship's order, my lord, only to the extent, my lord, of 1st of April 2026, my lord. But kindly, my lord, takes it up with question of 14, my lord, retired employees, my lord. At any day, I'm most grateful.
May I be permitted to mention a matter? This matter was on the last occasion, the matter appeared verbally instructed to
What do you want, madam?
to be listed in the
New application.
No, this was verbally instructed to be appear on 12th May, but it was not on the list. Kindly allow the.
Why did we give summary? You didn't appear on that date.
We appeared, but it was not on the list.
All right. After vacation, we'll supplement it. Record, note করে রেখো দিয়ে দিও নয়তো আবার এটা মেনশন হচ্ছে আগে ডেট ফিক্স closing list.
Participant writes apparent premium short password. He's coming from code number 19.
Who is your other side?
Other side is personally apparent. In person.
I'm praying for short password. My senior is engaged in another courtroom number.
What?
My senior is engaged in another court.
Where is your senior? Who is your senior?
From Venice. I'm praying for a
But
short
is there, you were asked to come with any evidence?
No, first time it's happening.
First time it is. First one? Yes.
Not in this matter, I'm
Not I appear for the upper. My lord, I'm sorry to have to come back to your lordships again, my lord. My lord, this was, my lord, the matter, my lord, which has, my lord, been before your lordships earlier.
Mr. Mukherjee's state is not there. We are suffering for 2 weeks. No state panel at
But here state is really not involved. They've made them a party. It's a private institution, your lordships would recall. My lord, this is, my lord, the RP Goenka school where there was an incident of bullying. My lord, in my lord, a trip, my lord, to Jaipur, my lord, for my lord, a sports meet. My lord, your lordship requested me, my lord, said don't take all these objections now, at least allow him to sit for the midterms. My lord, your lordship recorded that in the order, my lord, that my lord paid me a compliment that my lord I would. But my lord, the point, my lord, with regard to maintainability, my lord, of such a rate, my lord, was, my lord, there, my lord, before the learned single judge. Your lordships, my lord, did not interfere with it. My lord, we argued, my lord, that the writ is not maintainable. We cited, my lord, a decision of a learned single judge of this court saying that in disciplinary matters, my lord, my lord, unaided school, my lord, this, my lord, right to education, my lord, will, my lord, not, my lord, apply at all. Fundamental right to education. My lord, the learned judge now, my lord, after citing that judgment, recording it in the order, without dealing with that judgment, has held, my lord, that, my lord, the writ, my lord, is maintainable. So, my lord, we've come up, my lord, from, my lord, that decision. If your lordships, my lord, have a look, my lord, at that.
What
Here, my lord,
interim order has been passed?
no, there's no interim order. My
Petition is pending.
point on maintainability has been rejected. My lord, my case was, my lord, that the writ petition should be dismissed because, my lord, it's not maintainable at all. My lord, the impugned order, my lord, your lordships will find, my lord, in the memorandum of appeal, my lord, 22nd of April 2026. My lord, paragraph 8, my lord, your lordship will find, my lord, of this order. My lord, the objections, my lord, which I had taken. My lord, as to, my lord, maintainability, and, my lord, your lordship will find in clause E, my lord, I had relied on, my lord.
So where is that finding that your maintainability has been?
Yes, my lord, paragraph 13, my lord, kindly have a look. My lord, paragraphs 13 to 18. And then, my lord, at para 21 is the finding that, my lord, a writ petition is found to be, my lord, maintainable.
So we decide it on affidavits. You can call upon them to affidavits, fix a date and decide your issue.
Please, my lord.
Now that interim order, you have complied with it. Now you have allowed the student to sit.
Yes, your lordship's order, my lord, I complied with. There's no interim order here.
Here, my lord, the trial judge's order was, my lord, that in the event the expulsion is found to be bad in law, my lord, they will have to convene a separate exam for the student in question. So, my lord, there is no interim order directing that the student should be allowed to take the final examination in the year.
When is your final exam?
Final exam has come and gone, man.
It is over.
Yes, it's over.
Now this expulsion order was subsequent to that.
No,
No,
prior,
thereto,
prior.
Prior thereto.
There was no separate writ file. My lord, they came with an affidavit which was taken on record by this order, and directions, my lord, have been given for affidavits there.
But what is our order? You are saying that
Lordship's
we have
order was pertaining to
From
the
the
midterm.
ad interim, my lord,
oh,
ad interim relief had been refused. Now, my
against
lord, when the matter came up, my lord, I'll show that order, my lord, to your lordship. My lord, kindly take the stay petition, my lord, page 88. This is, my lord, 13th February 2026. My lord, kindly come to page 91, my lord. My lord, page 90, I want to, my lord, draw your lordship's attention to page 90, my lord. In course of hearing and responding to our queries, your lordships have that, my lord. So and so has stated that the school would allow to appear in the midterm, which would be held on and from so and so. However, he shall not be allowed to attend his classes. Further submits shall grant inspection of documents and records upon which reliance was placed towards issuance of, considering the arguments as advanced, appeal and as are disposed of with the following directions. Then, my lord, your lordship gave the directions.
So after this, when the matter appeared before the last.
There's an
revision,
expulsion order, my lord, after this hearing. There was an expulsion order. Now, my lord, when the matter appeared for hearing, my lord, they wanted to file a supplementary affidavit, bringing the expulsion order on record and its challenge. That has been allowed. And, my lord, directions have been given, my lord, to deal with it.
So expulsion order has not been interfered.
No.
No, it has not.
So what do we say? What do you say as regards this?
My lord, with regard to the maintainability issue, my lord, which is the subject of this appeal, my lord, there cannot be any immediate urgency. So kindly allow us to file an affidavit and
But
come
in the
back after
meantime, my
vacation.
lord, the writ will proceed and will be decided. My lord, your lordship, kindly, my lord.
When is it made returnable?
My lord, not before the vacation.
Huh?
Not before the vacation, my lord. It's not
Very
before the
My
vacation.
lord, they have
Only
made an
that, yes.
application for preponement of the hearing.
Yes,
My lord, otherwise, my lord, it has been fixed. What's the date? July.
July.
Monthly list of July. Your lordship's take it up.
We will only,
in the month of June.
Yes, my lord.
This issue,
Yes.
the present appeal has been preferred. You are for the student.
yes, my lord.
That is the respondent number.
One, my lord.
1 and 2.
1 and 2, my lord.
My lord, 1 and 2, my lord.
Challenging an order dated
For my lord, I am for the appellant, my lord.
My lord,
The state is not also appearing, so adjourn, my lord. Next Wednesday, my lord. Fix on Wednesday. Wednesday or my lord after vacation, whatever.
1 week after vacation.
Yes. Yes.
Hello.
But this is my appeal.
Hello, Lord, Senior Advocate Pratik Dhar is engaged in one Supreme Court matter. Kindly praying for not today.
Is for the state.
Ms.
Any-
Kaputi Shamanto is appearing for the state, my lord.
Yes.
We had a talk with her, my lord. She said that unless she got new instruction, my lord, she cannot appear. But the answering respondent is the Madrasa Service Commission.
Madrasa Commission. No, we directed exchange of affidavits.
The exchange of affidavit is complete, my lord.
What is the issue?
The issue is not following the guideline framed by the Madrasa Service Commission while conducting the 7 SLST. Well, they have not followed their own guideline.
Pertaining to the vacancies declared by.
No,
this-
no, not vacancies, my lord. Pertaining to conduction of the examination itself. Well, in the guideline, my lord, they have stated that the questions will be in Arabic and English in both languages, and the answer option will be in Arabic. But they have not followed in respect of 10 questions.
Now examination is over.
Yes, examination is over, but the final panel is yet to be prepared, my lord.
Then we will keep it after the vacation. Final panel has not been published. Then what
But
is-
they may publish the final panel. My lord, may I get a date after the vacation?
10th June.
Obliged.
Lordship, on behalf of the private respondent, Your Lordship.
My lord,
Lord.
this is the second SLST matter. I am praying for not today, my lord.
Lordship kindly records my submission. As per the earlier order, Your Lordship has allowed me not to place this order in front of this matter, Your Lordship, and I have not to place this matter, Your Lordship. I have came up with the client's instruction. Not these are my
It
instructions, Your
is not
Lordship.
your appeal. It is
I
your
want to
appeal.
withdraw this application, Your Lordship.
Uh-huh.
I want to withdraw this application, CAN application.
No, who is the appellant?
Oh, yes. You are seeking addition of party.
Yes, Your Lordship.
The plea that is similar issue, another petition
Yes, Your
is
Lordship.
pending.
Yes, Your Lordship.
Petition is pending.
Yes, Your Lordship. As
You said that if the appeal is dismissed, your petition will be
yes, Your
automatically
Lordship.
infructuous. Okay. And hence you are
Yes, Your Lordship. I have came up with the
application for addition of party. You are with
yes, Your Lordship.
Mr. Sachansar, learned advocate, appearing for the applicant
700.
My lord, I am for the petition, my lord. Last occasion, your lord says dared the respondent to file affidavit in opposition, but till date they have not.
I am for the appeal. On 17, there was a direction to file an affidavit, which is in respect of shortfall of service. Delay occurred due to the authorities not to give me appointment letter. Mr. Mukherjee was there. They
This is pensionary benefits.
Yes, my lord. Shortfall of service, my lord. Recommendation made January, but appointment given, my lord, December after 11 months, and delay is for shortfall 7 months or 8 months. Attributable to the authorities, delay caused. Your lordship's judgments are there.
What to do, Mr. Bishop?
My lord, let it be on 9th. Let it be on 9th, my lord. I have to serve again. New
They have
panel.
not used any opposition.
No, till date we
They
have not got.
used because their panel has been cancelled.
My lord, till date we have not got any opposition. Matter was, my lord, not disintegrated since in the first day writ petition was dismissed. That is why they did not get any chance to file affidavit. That is why your lordship granted them.
10th June.
10th June. Grateful. Same. 10th June. Great. Much obliged.
On repeated occasions, my lord, last chance was given to file. Allow them to file, my lord, the opposition to the Section 5 application. Till today, no copy has been served upon us.
Yes, why you are not filing the opposition?
Yes, it's ready.
Where is it?
It's ready.
Last occasion also nobody appeared
yes,
on
it's here.
their behalf.
It's here.
Who has filed the addition of party application?
Lord, I believe 2 persons who are related to the persons who have been who have been directed to be absorbed in the service of the.
You have been served.
They have still not been served with the copy of the application. Well, they are sought to be incorporated. There is a proposal for incorporating in the body of the college. Proposals.
My relative are trying to participate in the proceedings.
Lordship, that I don't have a copy of that application even. But I am led by Mr. Mojumdar. He is online.
My lord, your lordship may recollect, my lord, for the umpteenth time, the respondent, I mean the private respondents, the writ petitioners are seeking adjournment just to oppose our Section 5 application. My lord, no affidavit in opposition has been till date, subject to correction by my learned friend, has been filed in this matter. My lord, though there is a delay of about 7 years, but my lord, this is caused due to fraud practiced upon the court as well as on the university, as well as on the college. My lord, we have spelled out the reasons in our application. If your lordship kindly takes our application for once.
Mr. Mojumdar, they have come with an opposition.
They have come, but now, my lord. Well, give us just kindly keep it just after reopening then. Kindly keep it just after reopening then. Well, this is not very unfortunate. Maybe whatever it may be, my lord. Whatever it may be.
Application for condonation of delay as filed on behalf of the writ petitioner respondent.
Petitioners.
Writ petitioners.
Condonation of delay is by the respondent appellant.
Respondent condonation of delay is filed by the respondent appellant. Respondent in the writ petition.
Affidavit to the Section 5. Affidavit in opposition to the application for condonation of delay as filed on behalf of the writ petitioner respondent.
Grateful, grateful. Absolutely.
Lead petition.
No, there are around 11, 10 or 11.
You are representing all.
I am representing everybody. Only one thing remains, pagination is left. Affirmation has been done.
Has it been affirmed?
Affirmed, it has been affirmed. Only the pagination is left.
My lord, how affirmation is possible without pagination?
Everything is done.
Pagination, how can you affirm?
How can it be affirmed?
You
Only the
cannot touch it after the affirmation is over.
We will reaffirm it once again because today is a day for the filing the.
No, not today. This is the.
This was, but since the matter is listed, I'm at the.
File it now.
Within 10 minutes. Within 10 minutes.
No, we cannot give you the time to paginate now after affirmation. We do not know what are the documents.
No, we can reaffirm it once again with the.
No,
then the lordship accept it the way it is. Judge sir accept. Reaffirm করতে হবে তো এক্ষুনি করেছি
taken on record. Copy of such affidavit have been handed over to the appellant in court today. The appellant pays for extension of time to file a reply there. Stop in view thereof, then that let such affidavit filed. Filed within a period of.
Just on the reopening day, we will file.
Within a week after the vacation.
Very well, my lord. Very well. My lord, only one submission. My lord, may I just make? My lord, we are not seeking extension. Since they're filing affidavit right now, we can only file reply after filing of affidavit.
You have done so. You have done so.
But may I take your lordship's kind leave, my lord?
You're already on leave. What leave?
No, not on leave, my lord. Not on leave. I'm sorry.
14th.
Instead of 14, can you take it on 16? 1-6. Sholo.
Extension. By 1 week after.
1 week after. Raise the matter for further consideration on
16th June.
On 16th June.
You keep 2 copies of paginated opposition ready on 16th.
Paginated opposition? I mean that.
Come with that.
And meantime, we'll serve.
Meantime, no, you will serve it just now. Opposition.
Without pagination.
We'll paginate.
Great.
What?
I'll be getting that. I expect.
Pardon?
No, I didn't receive that copy. I'll be taking from him.
Copy has.
No, we have recorded.
Because I have to come again on the next day to have the copy.
No, why? Call Mr. Banerjee. Call Mr. Banerjee. You're apprehensive that they won't give the copy.
Obviously, we are waiting for this opposition.
Yes, Mr. Banerjee, what is
For the state.
state who is there?
Actually, the commission is the answering respondent. West Bengal.
Commission also same problem.
Same problem.
1 week after petition.
Kindly fix a date. Kindly fix a date. Because counseling is going on.
18th June করে দাও 18th June. You want to file any reply?
Affidavit of service.
Affidavit of service. Keep it with.
Good.
12 and 13.
I am appealing for the respondent university, madam.
Grievance is against you.
Or the
State is involved.
state is involved.
No, this is just a little bit. In a writ of quaranto, only the necessary and proper party is the
State has to be there, Mr.
no, let me say, but there is a decision of the Honorable Apex Court, Honorable Supreme Court in the Constitution bench of the Supreme Court in B.R. Kapoor versus State of categorically laid down the procedure for a writ of quaranto. In a writ of quaranto, onus lies with the person against whom the petition has been filed. And in that case, Supreme Court held that it is not necessary to make the employer as a party. So therefore, if state in this case, one thing is that writ has to be issued, it is a prerogative writ. It is a prerogative writ. It is not the substitute for mandamus or certiorari or writ of error. Court is to look into whether the appointment is in accordance with the statutory. If there is no violation of statute, writ of quaranto does not lie. If there is no violation, the precondition of issuance of writ of quaranto is that one has to show to the court that there was a violation of the statute or statutory rule. So, my lord, he feels that there fix a date for final hearing on this case.
Now, why two appeals, Mr.
Pardon?
There are two appeals.
Two appeals. One is not. Why two appeals is there? At the time of the judgment day, another petition was filed in 2020 without giving any notice. That was tagged on 2020 without giving any notice, and the petitioner, it was first 22. My lord was sitting single. No, it was not heard. But point is that he participated in the proceedings. There are several judgments, including judgment of my lords.
By the order, two writ petitions were dismissed, right?
Yes, two writ petition was tagged. In one writ petition,
yes.
So this first was a participant.
the state is answering is there. I want quite clear.
You have filed that application, Mr. Chokku?
Yes. My lord, one thing state is required only for one purpose.
Where is that application, Mr.?
Application is filed in court.
We gave you time on 6th April to file the application.
My application is to just submit to
additional document.
RTI.
Where is that?
That is with copy with the court. Is that submitted with the court?
Where is that fresh application? Your junior knows whether any fresh application, because
it was filed in the one department.
Filed in the department?
Yes.
That what is the CAN number?
CAN number 2? 2.
CAN পিটা আছে। Oh, আচ্ছা।
Why states one person is required? Because there is a reliance on the memorandum, which has not been gazetted. So state can explain whether it was done under Article 309 of the Constitution, whether it is the rule or not. Because a rule has to be gazetted. Unless a rule is gazetted, having no force of a statute or rule. So therefore, state can only explain because 2011 notification.
The presence of state is required.
On that point only. On that point, because
rule is who is appearing for the private respondent? Private is Osim Kumar Vishwas.
Both.
Mr. Chakraborty, it was decided upon exchange of affidavits.
Yes, yes,
Your
that is complete.
petition?
That is complete. Yes, in appeal.
In affidavit?
In the writ petition only two orders was there. In the absence of the two orders are there. In the absence of the private appellant, order was passed to inform that the matter will be heard on 20th. That is the order, and in absence of the writ petitioner as well as the appellant.
Whether both the writ petitioner was heard on affidavits or not?
No, both. One was heard on affidavit.
Whether that affidavit have you brought on record?
Yes, yes, yes.
Very good. But have you served?
Yes,
Cantu upon everybody?
Have you received?
Cantu
I have got you on 27 application.
No, my lord, that I have not received.
You have sent to the university.
Yes. Through mail, you have served this copy.
Through mail it also.
No, give a physical copy.
Physical copy.
Physical copy to find it.
So have you given physical copies to the other respondents?
Yes.
Private respondents.
Yes.
They received.
This
Not
is your,
this
this is your not.
They received hard copy. Through hard copy, they received and signed on the copy.
State.
No, state is not.
Upon whom so?
Whom I will say?
It's not complete.
You have to complete service, na?
State দিতে গেছিলাম কোনো জিপি নাই নেই।
We went. Clark went to the state. As there is no at present panel, so we will not accept it. What can we do?
এটা বলে দিয়েছে।
Number one. Number two, my lord. Even this is a two documents. It is the duty of the university to produce, not by me. I am volunteered to produce to RT application. As
we are not asking about, we are not concerned with the nature of the document.
Nature of the document.
Appeal court shall confine itself to the document and pleading used by the learned trial court.
So that is
always, it is the rule.
But that I know.
If you want to file additional evidence, then you have to file application, you have to cross that hurdle. Order 41 principle.
I order 47 rule 20, I don't know that for the question here is that this document, university issued the so-called notice after the judgment was delivered. After the judgment was delivered, university issued so-called to the expert, whether that is sustainably law or not. Even without the document.
You serve physical copies.
An application seeking leave to file additional document being can 2 of 2026 in
But they were saying you have not explained the copy. Yes, next. Item 14. 14 you are there.
In item number 15, I am.
15. You are in 15. 14. We are 14. One week after petition.
Type for the contempt applicant. I'm for the review applicant. You need petitioner.
Would you kindly come to the order impugned, order under review. Yes. Well, kindly come to paragraph number 18 and
Vital documents have not been considered.
yes,
So
though it was there.
non-consideration had led to such error.
Yes.
So
Well,
vital document which you could not produce the same despite due diligence. Where is that?
no, this is already produced. Well, kindly come to
Huh?
paragraph number 18 of the judgment.
You come to down of review first, then.
Yes, Madam.
So it is the ground knowledge that certain vital documents have not been
That should have been
considered.
because, my lord, my contention is this judgment was delivered with the premise, my lord, in the premise that this Joydev had not completed 10 years. Rather, we have not produced any document to show that this person, Joydev, has completed 10 years service. That portion. Lordship, kindly come to
This
paragraph
document
number.
was not with you when the
It
matter
is,
was
it
taken
is,
up.
it is
there.
there. It is there. It is there in the record.
Huh?
It was there in the record, madam.
Oh.
So that is the ground, madam. Kindly come to paragraph number 18. In the order impugned, the learned judge arrived at findings that no explanation had been furnished as to why a senior security officer, namely Joydev, who was the predecessor in interest of Supriyo, had been given a higher scale of pay for the same work. It was also observed that SINP authorities could not produce any rule or bylaws evidencing the fact that only people in 10 years of service could be considered for a higher scale of pay, and the authorities also could not raise any dispute with regard to the fact that the duties discharged by Supriyo were at par with his predecessor in interest. It was also observed that the SINP authorities could not even produce any document to show that Joydev had completed 10 years of service. Well, this finding is contrary to the document, Lordship, which could be found from page 79 of the CAN application, CAN 1. Page 79 of the CAN. Lordship, this was the letter issued on 1st February 2001. Kindly take note of this letter. With reference to your letter dated 9th November 2000, addressed to the director, I am to state that your designation has been changed to Senior Security Officer with effect from the date of promotion in the grade of 10,325 to 15,200, and this designation and grade are personal and valid for the present incumbent only. My lord, this was issued in 2001 when admittedly this person had completed 10 years of service. That was, he joined in the service. Kindly come to page number 200, which is
This document, Mr. Chatterjee, does not show that this promotion was due to rendition of 10 years of service.
My lord,
It doesn't appear from the
yes, Lordship, kindly read it along with page number 200.
page 200.
Yes. Well, this is my appointment letter, initial appointment letter in the SINP, page 200.
My means of Joydeep. Joydev.
Joydev's. I'm not
You are
Joy. I'm SINP. Joydev's appointment letter.
That is at page
200.
100.
Lord, you kindly come to May 8th, 1989. Well, may I read it? I am directed to state that your basic pay has been fixed at rupees such and such with effect from 1/11/1989. That is the date of joining as the security officer. It may please be that your appointment is subject to the rules and bylaws of the institute, and the conditions may be framed by the council and the director of the institute from time to time. I am further directed to state that you are such and such for the year with effect from 1/11/1988, and the period of probation may extend for 1 year. So, Lordship, this was the part, this is the appointment letter 1989, which was issued. And my lord, I have shown the earlier document. Kindly read page 79 along with page 200. That promotion was given in the year, which is annexed in page 79. My lord, it was issued on 1st February 2001. So 10 years, Lordship.
Maybe 10 years, but where is that clear expression that since you have completed 10 years, we are giving you the promotion?
Well, this was one of the limbs.
Justice Chakraborty says where it is written that due to rendition of 10 years service, continuous 10 years service, you are entitled to get the promotion, and hence you are promoted to such and such.
Well, let kindly come to page number 1.
If any promotion is acquired upon completion of 10 years, that cannot be personal to or specific to a particular.
Well, since we are on review, my lord, I'll kindly come to page number 132 once.
Mr. Chatterjee, that becomes a ground of appeal because you are saying that the court had misconstrued the fact that it is only upon rendition of 10 years he was given the scale, and that is supported by your documents at pages 79 and 200.
But the court, my contention is not that.
We have said that it was observed that SINP could not even produce any document to show he had completed 10 years of service.
Well, this is the document which was there.
Please read the sentence at par with the earlier observation.
Well, it was also observed that SINP authorities could not even produce any document to show that Joydev had completed 10 years of service. On contrary, my lord, SINP had produced these two documents, which shows clearly that he has rendered 10 years of the service. Well, these two documents were the part of the petition, our document, affidavit. Paper book, it is part of the paper book, my lord, kindly consider. And there is one point I want to point out.
Yeah, just a moment, let us answer. This was not our observation. This was an observation of single judge.
Your lordship affirmed that.
We have not affirmed. We have said that this discrimination was without any answer. In the wake of such discrimination practiced by the authorities, the learned judge directed grant of pay. The reasoning is a plausible one. This is our find. The reasoning given in the order is a plausible one, more so when service jurisprudence evolved by this court postulates all persons should be treated similarly.
My lord, my humble submission is that this observation by your lordship, or finding by your lordship, was arrived on the basis of the fact which was recorded by the learned single bench that SINP failed to produce any documents. So this was one of the limb on the basis of the learned single judge arrived at that finding. And your lordship was pleased to not to interfere with that finding. My lord,
hey, Mr. Chatterjee, then doesn't it become an argument on merits? We are already functus of issue. You are saying our judgment is erroneous since you have taken into consideration an erroneous statement of the single judge. Because the records would reveal that this finding of the single judge was erroneous. It was flawed. So this is an argument which is for you to advance as an appeal against our order, not as a review. Because the documents are already on record, it is a construction of the documents. You are saying that you should not have construed those documents for granting relief to me. This subject to correction, Mr. Chatterjee, you are re-arguing the case before us.
I'm limiting my argument with only two documents, my lord.
79 and 206.
I'm limiting my arguments, my lord. Your lordship has affirmed the finding arrived by the learned single judge that because of these two documents, the 10 years proof of the service, which was important, my lord, that was not, your lordship has found something different on the basis of that since there was no documents furnished. But these documents was available with the record, my lord. My submission is limited to that. I have no more submission, my lord, on the basis of that. Only I want to indicate one rule, my lord, that 132, page 132, my lord, the assessment for promotion before that, then the duration of service, which is the part of page 132. Lordship, kindly consider an employee 2222, an employee who has reached the salary grade 6500 such and such through promotion or promotions has to serve a minimum period of 10 years. So that is the rule.
Yeah, page 132.
132. My lord, kindly come to this 2222.
It is a rule of 2019.
Yes.
It was submitted that this rule is not applicable to the petitioner.
But lordship is not.
Petitioner was appointed prior to the introduction of this rule. That apart, this rule is applicable to whom?
Lordship, so far that is concerned, whether the applicability, that was not the subject matter of the judgment matter.
It was stated that this rule is not applicable.
The Lordship did not give any finding on that.
Previously, it was shown to us. I just now am not applicable to management and administration who are attached with management or administration, anything like that. It was stated to us earlier occasion
was
by
stated.
Mr. Bose.
But your Lordship has not dealt
I have
with it.
stated that in the written arguments also.
Where is
This is being filed as the 2004 rules. It does not appear from record, but even taking it to
now
2004
it
rules,
says
it does not apply.
2004 rules. Your appointment is 19th September 2004. When 2004 rule was introduced.
My lord,
Or given effect.
my contention is that what is being shown as the 2004 rules, it does not appear that it is the 2004 rules. Nothing from the record will show that it is the 2004 rules, which could have had applied. First, they had, my lord, attached credence to 2019 rules. I pointed out that my promotion was in 2011-12. Then they said that this is a 2004 rules. I said that there is nothing on record to show that this is 2004 rules, number one. Number two, even if we take it to be 2004 rules, I had elaborated in my written notes of arguments why it should not have any bearing on my case. So, my lord, whether I have pointed it out rightly or wrongly, this has been in fact considered by your lordships.
These 2 points. So 2004 rule have not been brought on record.
Never. Till this date, no.
Where is the discussion as regards 2004 rules?
There was no discussion.
It is new point.
The new point.
New point you are taken in review. Gown as a ground of review.
Lordship, I am only limiting it on the basis of 2 points, nothing else. Only this was not considered. I am only discussing about the result, that how these 2 documents will have some bearing on the judgment matter. That is my. I am limiting my argument to those 2 documents. It ought to have been considered by this. That is my submission.
Lord, 2019 Lord, discussion of your lordships is made.
Okay.
Who is the Supriyo Gangopadhyay?
Is
My lord,
that
my client who is the writ petitioner and my lord also the cross objector before you.
So you are contending that he was given promotion to the next higher grade on the basis of 2004 norms. This is your argument. Did you advance that argument before us?
Well, that argument was not taken up by your lordship. Your lordship.
There is a reference, no?
Reference of 2019.
2019.
2019.
Rule has been referred, lordship. May I read the paragraph?
Which paragraph you are reading?
Paragraph number, my lord, 14. He argues, it is Mr. Bose's argument, he argues that the order dated 29/7/2022 impugned in the writ petition was passed placing reliance upon 2019 norms, which could not have been applied since Supriyo was promoted in the year 2012. There is no provision as regards promotion to the post of senior security officer in the bylaws of SINP, and clause 12 of the bylaws provide that in absence of the provisions of the bylaws, the corresponding Government of India order shall apply. In view thereof, the security manual adopted by the Department of Atomic Energy becomes applicable, in which the pay scale rupees 10,000 to 325 to 15,200 has been provided to be the promotional scale from the scale of rupees such and such. The appointment of Supriyo Gangopadhyay was done in accordance with the rule.
2004.
Yes. That remained unchanged in 2019.
Yes, Mr. Chatterjee. Anything else, Mr. Chatterjee?
Firstly, coming back to the first point which Mr. Chatterjee had argued that, my lord, the paragraph which was shown to your lordships of your lordships order, paragraph 18. My lord, firstly, I contend that it has rightly fallen from your lordships that this is an observation of the honorable single judge which was taken into account by your lordships, and this finding written by your lordship is on the finding of the honorable single judge. So it cannot be a question of not taking into account any documents which was on record, but to return your lordship's finding on the findings of the honorable single judge by taking into account the materials on record. That is point number one. Point number two is on the same argument. I say, my lord, most respectfully, that even if it is said that 10 years of service was rendered by my lord Joydev Maiti, my predecessor in office, when he was, my lord, appointed. First, it has, my lord, already rightly fallen from your lordship that it appears nowhere from the records that this promotion was given to him because he had, my lord, served for a qualifying service period of 10 years. Number one. Number two, Joydev Maiti, my predecessor in interest, my lord. It has rightly fallen from your lordships that nothing is still on record to show that he had been given the promotion in terms of so and so rules because he had spent the qualifying
Where we have
service.
said that? Where have
No, my
we
lord,
said?
it has just fallen from, my lord, your lordships.
Don't take away secrets from us. It should be your where we have seen it is for us to decide. You show that where is the secret.
No, my lord, may I?
Just because my brother has put a question, you are passing on the buck to us. You are saying it is your observation.
No, it has rightly fallen from your lordships, my lord. Then may I, my lord, place it as my argument, my lord.
show us in support of that.
Because I cannot,
Your
my lord.
contention is that 2000 norms which Mr.
Yes.
Chatterjee is now placing reliance upon.
Yes.
This was not there in the records. 2000, this Mr. Chatterjee has relied upon these norms of 20, which does not bear a date.
Yes.
Page 130.
Yes. So, my lord, this was page 97 of the paper book.
Page? This was there in page 97.
97 of paper book. It was there.
So your argument is there is no material on record to show
that there was in fact
Joydev was given promotion on the basis of this page 130.
Or that I was given promotion under this page 130, which was 97 in paper book. So, my lord, my contention, if I may, my lord, read out from my, my lord, written notes which I had produced before your lordships, my contention is that this rule was, my lord, placed before your lordships for being, my lord, 2004 rules also, saying that this is 2004 rules, that is why it will apply. But I had said, my lord, if I may read out, just a minute, my lord. Technology does not support us always, my lord. At times, না ঠিক আছে, অসুবিধা নেই, সব আছে, written notes, yes. My lord, if I may read out, my contention was that the appellants relying on page 97 of the paper book, which is page 130 of the, my lord, review application, have claimed that the same is the norms or rules of 2004, which, however, cannot be substantiated from the records of the appeal. So, my lord, if your lordship takes a look at page 130 or the whole document, from nowhere will your lordships will find that this is in fact the rules of 2004. It does not say anywhere. If I may place, my lord, for your lordship's satisfaction. Page, my lord, 130. 130 of the, my lord, review application.
That is Mr. Chatterjee pointed out.
Yes.
my lord, will find, my lord, there is no mention of anything about what rule it is. And there is also a second leg of my
2019 rules. 2019 rules.
Lord, this 2019
predates 2019.
yes.
You have কিছু নেই।
সেটা কোথায় আছে?
Lord, it bears no date, nothing.
Then why did you argue this? If these rules are not relevant for your promotion.
I did not argue. My contention before your lordships was that simply stated that I was placed in the post of senior security officer, so I should draw a pay which was given to my predecessor in interest, which is Joydev Maiti. That was my contention. It was the contention of the Lord review applicants before your lordships in appeal that you cannot ask for it. Why? Number one, because you did not serve 10 years required service to be promoted. That is why we cannot give you that same pay. Number one. Number two is that the pay of Joydev Maiti was made personal to him on being promoted to senior security officer. These were their two contentions.
Subject to correction, my lord, my contention was, my lord, the highest post was the security officer. There was no senior security officer in the cadre. So, lordship, this was a nomenclature which was given. Well, that was my contention. I say it is the designation related nomenclature which was given as senior security officer. I have shown from the hierarchy, my lord, the security officer was the highest post in which he was promoted, my lord. And for that promotion, he got the revision. That was my contention, my lord.
My lord, with the deepest of respect, this contention does not find support in pleading, my lord. I stand to be corrected. This was never taken in the pleadings. Their contention was that, my lord, that for these two reasons I will be denied. And, my lord, the learned single judge as well as your lordships found that, my lord, there are no supporting rules which were placed before your lordships to substantiate that this 10 years minimum qualifying service is required.
No, kindly come to paragraph 4 of our judgment.
Yes. Well, 2019 norms, my lord, your lordships have possibly.
So where is those 2019 norms? norms were annexed.
2019 norms.
Your contention here is this page 130 predates 2019 norms. Now you relied upon 2019 norms.
He was promoted in 2012.
Yes, with effect from 2011.
With effect from 2000. Yes. Supriyo was promoted in 2012.
Yes.
So 2019 rule cannot be applied to Supriyo.
That was my argument.
2019, my lord, my instruction, it was upon instruction I had submitted this rule, which is already featuring in that page. That is the rule of 2004. The same rule is there in 2019 also. It remained unchanged.
So then how can you take this ground that 2004 norms were a different set of norms?
No,
self-contradictory.
Same. There is no different set of norms. That also had that.
How that will be a ground of review that in your review ground you have taken? Kindly come to ground 2, Roman 2. 2004 norms and rules applicable to promotions within Shah Institute which predate the 2019 norms.
Yes, well, for that certain material.
You also did not rely upon 2004 norms.
Because, lordship, we relied on that promotional rule.
That is to page 130, which you are showing.
Yes, that 10 years requirement for promotion, and that is the part of 2004 and 2019.
No, you relied upon clause 2.4. What is that 2.4 of the norms? 2.4 here is the assessment for promotion. This is one. Completing. So you yourself placed reliance upon 2019, Mr. Chatterjee.
2000, I placed reliance on the rule related to promotion. This rule related to promotion featuring in 2019 rule and 2004 rule remained unchanged, unaltered. So there is no difference. That is 10 years requirement is still there. It is on instruction.
Then Mr. Chatterjee, how you are saying that 2000 norms, 4 norms predates 2019 norms, and that rule, what is the error then? Following 2000, Supriyo had been given promotion. That is the private respondent.
Yes, 10 years he has given, my lord, promotion.
So then how does that constitute a ground of review, Mr.
My lord,
Chatterjee?
on the base, my lord, may submit. On the basis of 2 documents, your lordship had decided not to interfere with the plausible findings made by the learned single judge. The one of those grounds
That is the pages are
2
there. You
documents.
have no, as regards the norms, what is your argument that you are saying that there were existing 2004 norms which are predating the 2019 norms? That is kindly come to your review petition, ground 2, Roman 2.
Yes. My lord,
Then what is your stand today that this 2019 is not applicable? 2004 should be applicable.
my lord, if my stand is 2019 is applicable and 2004 is applicable, that will have no difference regarding the rule related to promotion. my lord.
Very good. Then that cannot be a, how can that be a ground that where we committed a mistake saying that 2000, you are today arguing that see, records will show there is a page 130. While delivering the judgment, you did not consider this aspect that this is a different set of rules of 2009 and predating the said rules, there was an existing rule of 2004. You are now arguing that no, 2004 principles and 19 principles are the same. Then what is the prejudice caused to you?
My lord, the principle is that 10 years requirement. Now, lordship,
That
kindly
you have
come
shown
to
us the document.
So this finding, which was arrived on the basis of the rule and the documents, your lordship, while opining that learned single judge's order is not required to be interfered, one of those grounds where this document we have failed to produce the documents. Now today, if your lordship kindly consider these documents are produced, then I have produced that this Joydev had completed 10 years, which is the requirement under the rule of service before getting the promotion. And your lordship passed this order on the basis of the equality, negative equality.
So where is 2004 rule?
2004 rules.
And 2004 rule and a clear finding that Joydev is given promotion only on the ground of completion of 10 years service.
Well,
that is not there. From the record you have shown Joydev have completed 10 years service.
Finding
Maybe we accepted. But promotion was granted only for this reason.
My lord, the only thing is that your lordship, while sitting in the division bench, had affirmed the judgment of the learned single judge. The learned single judge had arrived at that finding. My lord,
yes,
that was our contention.
That has not been your ground.
If your lordship kindly come to the grounds of appeal once.
218, page 218.
Appeal is
218. 218. 1 minute. Learned single judge order 218. Sorry. 1 minute. Hurry.
If your lordship kindly come to my grounds of appeal.
I'm coming here. Come to here. Learned single judge order. Got it. Yes, 214. 214, last 4 lines. Furthermore. Got it, 214?
Of the 214 of the paperwork, my lord?
No, you review application. Follow. Stay application.
Yes,
stay application. Sorry, stay application.
I got it, my lord. Your lordship is paragraph number 13.
13, last 4 lines.
May I read it, madam? The respondent SINP failed to explain why, after working in the same post and discharging the same duties, the petitioner was not be considered eligible to be paid in the same scale.
Furthermore, come to form
Yes,
further.
madam. There was no dispute raised with regard to the fact that the duties discharged by the petitioner were not at par with that of the predecessor of the interest.
Yes.
Furthermore, 6 number document has been produced to show that the petitioner's predecessor in interest completed 10 years in service. The impugned order is discriminatory and it's against the principle of the fair play.
It was the observation of the learned
Single judge.
single judge.
And
You
that
have not filed any application paying for rectification or modification of that observation.
I filed the appeal, my lord.
You have filed the appeal.
Now, this
But in
finding
your
is the
appeal,
march.
in your appeal, that it was a wrong observation, where is that ground? Come to page
But it kindly,
18 and onwards.
but it kindly come to once, paragraph, page number 219 once.
219 years.
219. My lord, this is a ground of appeal. Kindly come to
That is a wrong
4,
observation.
Roman 4. For that, the learned trial judge erred in law by not considering the relevant rules for promotion applicable in the institute, including the norms and procedure for the years 2004 and 2019. That was part of the ground of
No,
my.
my brother is asking you pertaining to page 214 that
Yes, ma'am.
no document has been produced. Did you take any ground in the writ petition that documents were there? Those were not considered.
My lord, yes. Chalo to rite. Rite chalo to. Rite bar karo. Yes, my lord. In the writ petition, my lord, I just find
You have taken.
I've taken.
So show us that ground of appeal, Mr. Chatterjee.
Grounds of appeal, my lord, it could be found in to page number 219, my lord. It starts from 218 onwards.
Huh?
My lord, kindly come to 219 Roman 4.
Roman 4 you have showed us.
Yes. Before that, kindly, Lordship, kindly come to from Roman 3. For that, the learned trial judge erred in law while recognizing that said Joydev Maiti, the predecessor in interest of your petitioner, learned trial judge has also erred in law by coming to a finding that said Joydev Maiti is the predecessor in interest of the petitioner without perusing any material on record in all aspects, including the appointment, fixation of pay scale, promotion and superannuation of said Joydev Maiti. Thereafter, my lord, this 2004 and 2019. Thereafter, my lord, kindly come to this ground number 8. This is very important, my lord. For the learned, page 220, learned single judge has erred in law by not appreciating that as a result of the re-designation of the petitioner respondent in 2012 as senior security officer, petitioner's pay scale was revised in pay band of rupees 9,300.
am for the petitioner led by Mr. Indrajit Dasgupta, my lord. Kindly take up this matter after vacation, my lord, because he is not available, my lord. It is an assigned matter, my lord, appearing first time before your lordship.
You are for the review applicant.
Petitioner, my lord.
It's a contempt applicant. Who has filed the review? Oh,
18, my lord. 18.
WPCT.
আবার আমাদের কাছে সেই কার কাছে ছিল সাহেবের কাছে ছিল CP
WPCT, my lord.
WPCT.
It is assigned matter, my lord.
Understand what was the WPCT?
My lord, it is with regard to giving taking the date of appointment from the date of ad hoc appointment, my lord. Now the tribunal has allowed, my lord, that the date from which the ad hoc appointment was given, all benefits will be given from that date, my lord. Now there were similar matters, my lord, which went up to the Supreme Court. But here, my lord, we have points here that these petitioners, my lord, the applicant before the tribunal, they were fence eaters. First point, what we have taken in this matter, my lord. And second is, my lord, whatever the judgment which has been considered in the previous round of litigations.
Go a bit slow, sir.
My
You are challenging an order passed by the
tribunal, my lord.
Central Tribunal before us.
My lord.
You are for the
Union of India, my lord.
Oh, you are for Union of
My lord.
Acha, what did the tribunal direct? Can you show us that order?
Lordship, they directed that, Your Lordship, a brief background. I'm for the respondent. There were 25 doctors who were appointed on a ad hoc basis all over India by the Ministry of Labor. And later on, after a spate of court cases, what happened was they were regularized from 2014 by order dated 2016. Some people one lady in Hyderabad and 7 other doctors in Madhya Pradesh, they all went to the tribunals there. And the lady in Hyderabad, she won in CAT Hyderabad, Telangana High Court and Supreme Court, Your Lordship. And the question about, and then she has got it also, that has been implemented. Now Jabalpur also, tribunal gave a judgment in their favor, now upheld by the High Court also. This is the same has been followed by this tribunal. And as far as fence it is concerned, Your Lordship, may I ask Your Lordships to come to page...
when were you appointed?
In 1996, Your Lordship.
96. All of you were appointed.
In 96, 97, all of us were appointed.
So now their defense is that why didn't you come earlier?
Exactly, Your Lordship. Page 82 of the writ petition for a moment, Your Lordship. That's why I'll show why didn't we come earlier.
My lord, before your lordship is trouble, my lord, the Supreme Court has kept all law points open, my lord.
You are here to be troubled, sir. You trouble us today or trouble us tomorrow. What difference does it?
This is their senior list, page 82 of the writ petition. This was annexed A4 of my way in the tribunal.
82.
82.
82 of the WPCT.
Yes, Your Lordship.
This chart.
Yes, this chart. That just before that chart is the seniority list. That starts at page 82.
Yes.
And I take a lordships to page 87. Hey, sorry, 117. That internal page 87 of the way, page 117 of the WPCT.
You are in this list.
Yes. In please see this, what they say. The following 25 doctors who were initially appointed on ad hoc basis by Ministry of Labor and also regularized by this ministry's order number 4/2016 and appointed as medical officer in CGS cadre on 18/9/2014 on the advice of DOP. The names are as follows, Your Lordship. My name appears at serial number 19, Dr. Sanjay Bhattacharya. The seniority of the aforesaid 25 doctors is subject to the outcome of writ petition 3827/2019 by the Honorable High Court of Telangana, since the matter is still pending in the Honorable High Court of Telangana. When they make this statement, Your Lordship, I should not come earlier. It did not come earlier. My representation was pending. Once the Honorable High Court of Telangana I gave another representation. And before the Supreme Court, I was also a caveator and intervener.
Show us that order of the
Supreme Court order, Your Lordship, is at page 162.
ছেড়ে দিলেন কেন? ছেড়ে দিলেন কেন?
Your Lordship, 163 is the order.
Intervened. You intervened.
Your Lordship may see my name is the fourth for the respondents. We had filed a caviation and intervention application.
Your name, how did it appear as respondent?
Because I appeared, Your Lordship, because we had filed an caveat and intervention application, Your Lordship, in this. Therefore, I appeared. If Your Lordship will see my name, Tushar Ranjan Mohanty, I was the advocate there, Your Lordship, because they dismissed it on that day. Therefore, nothing further happened.
So where have you made that statement that before the Supreme Court you were an intervener?
Yes, Your Lordship. I'll show that.
Where is that paragraph, sir?
Lordship, Lordship.
So why didn't you tell the tribunal at that time?
I had, Your Lordship. I had. That was
Then
there.
show us that you made that argument.
Yes, Your Lordship. I'll just show. One second, Your Lordship. Just 1 second.
We give you 2 seconds, sir. Exeter বলছে
ট্রাইব্যুনালের পয়েন্টটা তুলেছিল, ট্রাইব্যুনাল কিন্তু করেন কমিউনিকেশন এই পয়েন্টটা
Point 11 starts in the earlier page. May see here, Your Lordship.
38.
Yes. 4th line from the top. The applicant was a caveator before the Honorable Supreme Court.
So the tribunal did not take notice of that.
Yes, Your Lordship, it had, and it allowed the way, Your Lordship.
Which paragraph, sir?
Whether specifically it's mentioned or not, Your Lordship, I'll just read that judgment.
First from the order.
Yes, Your Lordship. I'll just read the order which is at top.
Similarly situated, Your Lordship. Clearly situated. Applicant was among those.
Your Lordship, it's para 5.3, page 5 of the judgment, Your Lordship. The coordinate bench at Hyderabad, by its order dated 2008-2018 in OA number 285 of 2016, had directed regulation service of Dr. N. Swarnalata, the applicant in the OA, with effect on 28/1996, that is from the date of her initial appointment. This order was challenged before the Honorable Telangana High Court, which upheld the order of the tribunal, and SLP filed by the respondents before the Honorable Supreme Court were also dismissed. The matter of Dr. N. Swarnalata thus having reached finality, the ministry concerned issued a letter dated 3/4/24 regularizing her services with effect on 28/1996. That is the date of her ad hoc appointment. This OAM dated of 3/4/2024, however, states that this order of regulation of service of Dr. Swarnalata was in persona and was not to be quoted as a precedent. Judgments passed in coordinate benches of Hyderabad and Jabalpur in OA number such and such and such.
Proper, sir.
My lord, kindly grant us this week, my lord. We'll satisfy, my lord. There are a lot of points, my lord. If this is given in Mr. Indrajit Dasgupta, my lord.
He has no points. That is why he is not.
No, my lord. My lord, will satisfy your lordship. My lord, what will happen, my lord? Today, if the ad hoc is.
Union of India, you are the Union of India. You are not a. It is a fight between the lion and the lamb. Ultimately, the lamb has succeeded, sir. You are the lion. Why you are taking such steps?
My lord, kindly appreciate, my lord.
You have given 25 persons. He was not an outsider.
No, my lord, we have not given. My lord, kindly appreciates. My lord, one doctor succeeded up to the Supreme Court. My lord, after that, these people were regularized, my lord, by the recommendation of UPSC. Now, what happens here, my lord? Now, UPSC recommends them fit to be regularized. Now, if they are regularized from the date of their ad hoc appointment, my lord, the direct appointees, they will supersede the direct appointees.
He will come before us, sir. Why your problem?
My lord, that is why we had given effect to that doctor by saying that the result is in person.
Reopen that issue.
My lord, the Supreme Court.
Admittedly, they are similarly situated. Now, only you are denying this benefit to them on the ground that they are fence it.
Not only on that ground, my lord. Our
Stated the same.
my lord, that is, my lord, kindly appreciate that is one of the ground. Now there are other grounds, my lord, we will agitate before your lordship. Kindly gives an opportunity, my lord. Because in all
Fail, Mr. If you fail to satisfy us, you will be inviting costs, sir. So talk with Mr. Indrajit Jaj. We are not denying, but you are the Union of India. A person fighting litigation since 19.
my lord, one opportunity only.
And ultimately you give 24 and you skip off one person. Why,
Not 24 has not been given.
it's a very good
Only
joke.
one has been given.
How can you say that they are fence sitters, sir? They were from the self-same group. Telangana High Court said it will abide by the result. Then why they will go for multiplicity of litigants? They will wait for this. They were also filed a KB before the Supreme Court. Supreme Court took their presence into account. Even after that, you are saying that I will not comply.
My lord,
That will be at your risk and choice, sir. We will deal with your Union of India.
my lord, kindly give us one opportunity, my lord.
We will give you the opportunity, first rethink. But rethink, you are our officer. You are not the Union of India.
I bow down
Council.
before your lordship, my lord, but
So you pondered over this issue. Then it becomes unwarranted. This writ petition becomes an unwarranted decision taken on behalf of the Union of India. It is just for the reason of withholding benefits by hook or crook.
no, my lord, only these points have not been taken up by the Supreme Court, keeping the law points open. That is why we are before your lordship, my lord.
If the Supreme
And if your
Court
lordship,
kept the law point open, it is for the Supreme Court to decide that, not for us.
It is open for the Supreme Court.
May I submit, Lordship? In
my lord,
seven doctors
kindly
of-
give us one opportunity,
seven
my lord, if
doctors
we are
of,
not,
Madhya
if you-
Pradesh, Your Lordship, this is the High Court of Madhya Pradesh judgment.
We are High Court of Calcutta.
Yes, that's why the persuasive value it will have with my lords. I know it is not binding.
You talk with Mr. Dasgupta.
my lord,
That the court wants to know this.
my lord,
And if there is a decision to that aspect, see that the order is complied. Then
My
we will hear you.
my
but
lord.
you consider this issue. Consider this issue. Yes, when we will take up, tell us.
My lord, as per the court's convenience after vacation, my lord.
Situated. Petitioner prays for a short accommodation to avail instruction
Hey, password what happened to your password? Item number 1.
My lord, whether this our institution is subject matter of jurisdiction or not. Earlier, my lord was pleased to ask me. My lord, subject to question, my lord. Mr. Chaturvedi was appearing on behalf of the writ petitioner on behalf of the Honorable Single Judge, where it was said, subject to question, that Opimanyu Banerjee, Mr. Opimanyu Banerjee appeared. He's for the writ petition. He said that it comes within the purview of 226.
So your contention is that school is private.
Private in nature without financial institution.
And the relationship
Employer and employee cannot be adjudicated.
employer is a private. So here adjudication is not maintained.
Maintainable. This is my lord's judgment, and this is the judgment which is referred to the division bench conflicted to just
You just before that you come to internal page 2 of the order. Impugn.
yes, my lord.
Last paragraph. During argument, he would refer to the clauses 10 on 11th of letter of recognition issued to the school dated such and such. He submits that as per the prevalent rules, the school authority would be duty bound to afford opportunity of hearing to the petitioner as well as observe the due disciplinary proceeding before termination of service.
I put this,
Where is that?
the rules. That question I want to put to mention.
Clauses 10 and 11 of the letter of recognition. You take
yes. Letter of recognition, my lord, can you consider?
You have not mentioned.
Approval. It is not the recognition that it is the approval.
Clause 7 of your appointment letter. At
Yes.
page
My lord, can you
48.
turn to page 48 of the stay application?
Yes, we are there.
With the my lord will find a 4th-class junior high school without any kind of financial aid from the government of West Bengal. 4th class. Now, my lord, managing authority shall be 3. The school authority shall provide retirement teaching and non-teaching staff school as per death benefit scheme. Now, my lord, 8 and 11, what?
7.
7. If your lordship, the recruitment of teachers shall be done in accordance with the transparent merit-based criteria as laid down in the relevant government rules and government orders, and the information that shall be made available to state government if necessary.
Now you are saying no government order is applicable upon me.
It is not appointment, it is absorption. This is not a new appointment. What, my lord? It is a primary school where this person was working. Now our school was graded to a girls' high school.
Where is the second page of this memo?
It's not annexed, it appears. আমাদের কাছে ছিল না একটা? আমি বার করতে বলেছিলাম। এই মেমোটা বার করো।
What is the wrong in the order then?
No, Maharaj.
Only said that you give him opportunity of hearing.
No, after that it was set aside and it was directed to pay all the arrears.
Yes. Naturally.
If court finds anything done illegally, then what would be the
No, Maharaj, illegally, Maharaj, even if Maharaj Kali consider it is a breach of trust.
only justification?
It is a breach of trust. But I'm taking that way also. It is a private mutual that I will pay you this much of amount of money.
No, Mr. Roy, kindly come page 48.
Yes, Maharaj.
This is a letter you are saying of not of appointment but absorption.
48, yes.
This is first recognition.
Yes.
And you have undertaken certain obligations upon your part to follow the relevant government orders. Now, next page 49 is your recognition memo, which is issued by the board, which specifies an obligation on your part. School authority shall provide retirement benefits to the teaching and non-teaching staff as per death cum retirement benefit.
Yes, if the recruitment, now Maharaj Kali consider this is the service rules of the school.
Ashur. Now, where is that clauses 10 and 11 of 24th October 2013?
10 and 11 of time. আমাদের কাছে এটা নেই It was handed over on the last occasion by the subject to question in the first day, my lord. Probably it has been handed over to your lordship, my lord, subject to question, my lord.
Yeah.
No,
an undertaking should be submitted to the board.
Clauses 10 and 11.
To the effect that the authorities of the school recognize shall abide by all rules, circular orders framed by the government of West Bengal and issued by the government of Board of Secondary Education from time to time. So,
now, man, can I turn to my evident reply?
10 and 11.
No.
Page copy. Recognition memo 10-11.
Recognition
এইটা হচ্ছে page 48. No. ওটাও হতে পারে 26/12/2013 এখানে 10 আর 11 টা তো পাচ্ছি না না এইটার সাথে first recognition
Subject to question, if your lordship takes up page 47 once.
47. No, Mr. Rai, show us 10 and 11.
Yes.
The single judge said that in view of 10 and 11, there is an obligation on your part. A letter of recognition dated 26 December. This is page 49 is the 26 December memo.
As per prevalent rules, school authority would be duty bound to afford opportunity. Unaided school cannot be treated as a private. Okay. There is aided and unaided school.
It is
aided means who receive fund from the government. Unaided means he did not get any financial aid. Now, actually school was recognized. When school was recognized, recognition is given, then certain condition was imposed. What was the certain condition? That you have to recruit the teacher as per the recruitment rules. That apart, you will give them benefit as per the local rules. And you shall be bound by the rules made by the West Bengal Board of Secondary Education from time to time.
So this is the contract.
Is the rule. So your status and the status of a purely private school is totally different.
Subject to question, my lord. Here, my lord, I am joining issue. Now, my lord, the right was there. The right is there. Forum for enforcement of the right. A contractual obligation, my lord, can you consider? My lord's judgment was there. If it is a contract between the state and the private, I want to enforce that it is a contract.
No, why you are terminating him? We are a constitutional court. We have a right to know what was the reason.
Yes.
It is a defense on your part. That
Page
you cannot
60.
entertain.
Page 60. If your lordship may kindly consider.
Page 60.
Yes.
60 is a representation.
Yes. My lord will find he was directed. His letter, my lord, I am reading, but where is the termination? There is no termination. He was directed to go and teach to the school where he was initially parentally appointed. This is nursery section.
Show us his appointment
Yes.
letter.
Page 47. My lord, can you turn to page 47?
So first one goes, you are going to the merit.
Yes.
Your
Yes, my
first one goes. Now you are inviting us to enter into the merit.
No, as followed from your lordship, I can, even if I am on this writ application is not maintainable. Irrespective of fact, while same act came up for consideration with the Honorable Apex Court also. And with the division bench of the coordinate bench by your lordship. The reference was made. If this is a contractual, it is an employment dispute, whether the petition is applicable or not, is maintainable or not. That I am coming, my lord. Before that, এই আছে না মেমোটা আলাদা এটা 15 একই মানে I get told that in 10 and 11 মানে I have only one copy with me.
What is that?
That missing page 10 and 11 clause 10 and 11 before that. As director of the managing committee, I to inform you that
That's some rule.
yes, that is a service rule. Yes, then which is the initial appointment. Now I'll carry it to page 47. This is to certify that Ovik Chatterjee, son of Shankar Prasad Beldaga, such and such, has been serving in Pranab Bharati, an academic and philanthropic institution with nursery and primary classes since 3rd January 2018. He is very popular, friendly with colleagues. He has a lot of popularity not only amongst the stars but also amongst the guardians of the young, energetic, dutiful, and always alert in regard to well-rounded development of the students. Good and nature, moral. So he was predominantly appointed in a primary section. Now this school was recognized as a class.
This rule was promulgated by the Bharat Sevashram Sangha.
Yes. The school under which. Yes, madam.
Notified.
It is the service condition. Well, the service.
From you get
It
the
is
rule making authority.
It's my employment. I wanted that I am in a school. I want to appoint you in this service condition. Whether you will accept it or not, it is up to you. If today, my lord, if I want to engage any person, this is the condition which I am circulating. If you want to admit, if you want to join, you can join.
Then how can you supersede the recognition?
Yes. Now, my lord, can you turn to? So he was predominantly a teacher under the primary section. Till today,
Where is your termination order?
Yes. Now, my lord, can you turn to?
Apply to recognized institute.
That is why your logically turned to page. He stopped from coming since 2018.
Yes.
Yes, this is your upgradation memo, wherein 11 and 12. Now, if your argument is that no, we have our own service regulation.
No, it is for us to decide whether he will come in that. Because initially the appointment was Bharat Seva Sabha Sangha. The school which is not recognized at that point of time, primary section.
That is Pranab Bharati.
Yes, Pranab Bharati.
Very good.
Now, my lord, in 2018, he was started when the school was recognized. Now, my lord, he has to maintain that parity along with the recognition, that education qualification, other things. We directed you should go and start your teaching in the primary section.
No, where was his appointment?
Primary section, that is what?
That is your certificate you are showing.
Yes.
You don't have any appointment letter.
Page 45.
Yes, page 45. Yes. Pranavananda Vidya.
The unit of Bharat Seva Sangha Belanga. So it
your
is
assistant, you are selected, he is working from 2012.
Yes.
And you will be confirmed in the subject to successful probation. So he must have been confirmed. And now you shall obey and follow the rules and regulations of the school board applicable in case of unaided school.
Unaided school, but it has not been recognized at that point of time. That is what I am. This primary section was not recognized. It is a private school. Recognition come later.
Now the recognition was given initially on page 48.
Yes, my lord.
Page 48 is the recognition memo.
13.
48. No. First recognition of Pranavananda Vidya.
Yes, now it is converted to first recognition of Pranavananda Vidyapith girls.
Very good. Girls, yes. Previously, it was not girls.
Not girls. That is why he was a male teacher. He has said initially he has started teaching over there. We have requested to go to the primary section because
should have heard him at least. You should have heard him.
Yes, he did not join. That is what he himself.
Your joining is in supersession of his earlier order of appointment.
Earlier, that is what I pointed to your lordship.
Appointment order is 20th January 2012.
Yes, that's primary section.
Primary section. Now you are saying that we told him that get lost from here, go and join the higher school section.
No, primary section.
Where is that letter?
Yes, that is why my lord, if you logically his representation.
Oh, no. Where is that
page
letter?
60, my lord, that is why my lord can turn to page 60.
Page 60. 60 is his letter.
Yes, from there it is admission on their part.
Your letter that you go and join the primary section.
It is not that we have informed him. Informed him that go and join.
Since he joined, you are taking coercive measure. Since he is not joining in the primary section, you are taking coercive measure.
Till today, there is no termination letter. That is why your lordship, the first occasion directed, if he wants to join in the primary section, he can join.
Asked, but he is not willing.
So
if then you show us how can you throw out a teacher from the primary section, saying that as you have sought for, I am sending you there. No, relying upon page 60. He might have said many things on this representation. Now, your contention, Mr. Roy, you are saying we told him that go and join the primary. So show us that letter, sir. Suddenly, you act upon a representation of the person and you are stopping his salary. How, Mr. Roy?
Subject to question, if you logically consider it that way also. This is a school where it is directed to.
You are an organization recognized by the board under an obligation to follow certain rules. So very good. That recognition came to you way back in the year 2013. Now this person was working in the primary section. Now you are saying that since it's a girl institute, girl school, we have show us the termination letter. Oh, no.
Termination letter is not there.
You have not paid him since the year 2012.
Yes.
You have a managing committee.
Yes.
Huh? For the
Not
management.
managing committee in terms of these rules.
Huh?
We have their managing committee for the primary section under the.
No. We come to your page 48, your recognition member.
Yes. So class 4 class junior high school.
Come to page 49.
Yes.
As per the honorable administrator, please to consider report and recommendation of state government grant first recognition girls junior high Murshidabad Bengali as first language Bengali provisionally for 3 years as a 4th class junior. Now this managing committee school authority has also been recognized that has came in the writ petition challenging what?
Page 55, my lord, kindly consider page 55 once. What is the cause of action for filing of the writ application?
You have filed your reply.
Demotion of service.
Demotion of service. Further, regret to mention that at the time of demotion of service of our client as made by you only on the abuse process, will raise please protest to our client by saying the school committee has decided not to give any male teacher anymore. All the male teachers who were working for gain at the time of the instruction, all of them were removed from this said school and early possible. And client believe that he was removed from reason no male teacher would be remain in the girls' school. And you have definitely keep the words or said client compelled to join the primary section only due to some how maintain the livelihoods. I got it.
এইখানে একটা ডিমোশন অফ সার্ভিসের ইয়ে দিয়েছে পেজ 55 পার্সেন্টেজ টু মেনশন at the time of demotion of service to your client, you personally assured him to take back in high school.
Page 56, first paragraph, last 3 lines.
When did you stop salaries?
He came to school, page 94. January 2018, we have paid as a primary school teacher. His salary, my lord, will find page 95, 13. Accepted.
So when were then he continued there up till which time?
December 19, January 2020 till we have paid. Page 97. And writ application was filed sometime in 2021.
He was initially appointed in 2012.
12.
So in 2018, you told him to go and join the primary school.
Primary school section.
Then what happened?
He joined, paid up to 2020, I have page 97.
Page 97.
7. Last.
Paid up to 98.
The recognized unit or non-recognized unit? 3,000.
This is another school.
1,700,
It is not the recognized school. It is the school by the Bharat Seva Sangha for imparting education.
No,
it is not recognized as
You giving this salary to whom?
Which Chatterjee? It is the school which is there, primary section.
In primary section, 14 teachers are employed. Primary section. So big primary school.
Probably, my lord, that is the only primary school in Beldanga which caters the need of the particular community.
No, in 2018, he joined
Primary section. Up to 2020.
Now he worked there till 2020. Then after 2020, what?
Filed this writ application based on the fact that I illegally demoted. Filed this writ application on the plea that I have been illegally demoted.
Demoted. So where is that order asking him to go and join the primary?
That order is not there. From their own document, I can satisfy your lordship. Their own.
You have used a reply, Mr.
Yes, the reply
application does not contain.
No, it was heard out of turn, allowed ex parte that your lordship find out the order itself. No affidavit, nothing.
They have now filed an affidavit. Now, what is your problem? Why you are showing him up?
We have till today, on the last time I said, go and join the primary section. He will intend to join in the girls.
Because primary section is the girls section.
No.
Achha. So
you are sending from recognized unit to a unrecognized unit.
This is recognized unit, my lord. It is his appointment in the year 2012. At that time there is no recognition. He was catering the just for the purpose of the school. He was allowed to work. Now it is a girls' school.
Unit, one is entitled to get pay scale according to the as prescribed by the government.
Yes, provided he was appointed in that school. Provided, my lord Kali, here is where is the appointment in terms of the rules. If, my lord, today somebody is allowed to a past class 12 past candidate allowed to teach in the higher section, whether he is entitled to get the same salary, irrespective of appointment by the authority, it may be ground for initiation of the proceedings against me.
Where did you send him? That he was working in
the parent school from where he was appointed. Pranavananda Vidyati Ashram.
He was appointed as an assistant teacher in which school? Page 20.
Pranavananda Vidyapit, page 45.
Page 45. Page 40. He was appointed. Then what happened?
Now, subsequently, this school was recognized as class. This not this school. The school was recognized as class 4 junior high school, and it was converted to Pranavananda Vidyapit Girls High School.
Very good.
As there is no segregation at that relevant point of time, he was used to work in the said school. Now, my lord, there is some allegation the girls, my lord, no practical problem. No male teacher was allowed to continue because some allegations are there from the guardians.
No, this 4th class junior high school recognition of Pranavananda Vidyapit
Girls High School.
The girls high school was recognized from 13.
13.
He was not an employee in girls high school.
No.
He was appointed, page 45.
It's a Vidyapit.
Shows you have been appointed at Beldanga, which is a Pranavananda Vidyapit.
Yes.
Now it has been recognized as Pranavananda Vidyapit Girls.
Girls. Now, my lord, he was catering his service in the girls section. Some allegations, counter allegations. We said the school was still in existence. This institution now it is a separate institution for the girls. This is the institution runs by the Seva Sangha itself. You go and where you are presently appointed, you can start your job over there. He joined that side. I could not understand. He did not accept. 2018 to 2020, he joined.
2018 to 2020, he joined.
Joined.
Then
accepted. Now filed the writ application illegal demotion. So there is a pure contractual.
Pranavananda, Headmistress Pranavananda Bharati. Now since 3rd January 2018. There is a contradiction, contradictory statement.
Since 2018 it was in the primary section. That is what? What is the, my lord, I put this question to myself. If you recognize school, if you want to take the recognition on the basis of which you want to move an application to 226, my lord has to prove that he is under the statute, he is entitled to get such appointment. A wrongdoer, even a my lord kindly consider I have committed mistakes. Kindly consider that way also. Whether thus is entitled to invoke this jurisdiction and ask for an amount which is not permissible under the statute.
I don't understand one thing. In 2012, you invite a person and give appointment saying that you will be treated as a government teacher, treated as a teacher, you will get the benefit of ROPA 1998 and everything. Now, on the basis of that, this teacher continues even after recognition of the institution.
Yes.
Recognition of the institution brings you within the fold of obligations under the law purpose. Now, in the recognized institution of 2013, he continued till 2018. What salary he got, we don't know. Now, 18, you have asked him that you go and join the unrecognized section. How can you do so, Mr. Roy?
Because
he was an admittedly a teacher of the recognized section. You are asking him that, sir, you go and join our primary unrecognized section.
Yes, Madrasa.
He went. He went and joined there. Now in 2020, he realized that he is only getting a paltry amount of 3,000.
Yes,
so as per the regulations, he is entitled to the divisional benefits also.
I bow down to your lordship. Since 2013 to 2018, the amount which was paid is not in terms of the ROPA.
Not in terms of ROPA. He accepted.
Accepted. Now, my lord, kindly consider in other way. He accepted. Now, my lord, if a VN has been made that you go and work there, it is my lord is considering that since he is appointed in the section, we are officiating this person was there in the private section at the relevant point of time.
So you should at least give a decent order that, sir, in these circumstances, you have accepted, you knew everything, you got the salary, and you will act as a what should I say? Act as the principal and say that no, we are not concerned. Show at least one letter that, sir, you accepted your service in 2018 to 20. Now you can rejuvenate the claim. You cannot re-agitate the claim now. You are stopped. That can be one of your argument. We accept. But your contention is no. REIT itself is not maintainable.
So,
Mr. Roy, if REIT is not to be maintainable, that should be on the anvil of some order which has been passed, relying upon a service condition of the employee concerned, whom you are asking that now you go and join there. So there will be now no basis, Mr. Roy. And you will urge that no REIT petition is maintainable against me. We are above everything.
Not above everything, my lord.
So you are saying that you go to the suit. Go and give private arrangement. You try to assert. We come back. You give a notice. We will hear it. We have extensively heard Mr. Royal and its.
So
the item 7 and 8.
Lordship, item
2
7 and 8, Lordship.
Yes.
I'm paying not today only. Kindly take it up after vacation any day, Lordship. The board is answering respondent, Lordship.
My lord, in fact, my lord, this matter was adjourned on the last occasion on the ground of Mr. Lokhi Gupta, who was supposed to appear on behalf of the
Board,
board.
Lordship. And
Now, my lord,
situation?
your lordship remembers.
Maintainability point.
No, my lord, this is
PTA matter.
leave to prefer appeal. But we are TET qualified, but my lord, we were interviewed, but our appointments are stalled for the reason, my lord, that one judgment is standing in the way. We were not parties in the said proceedings. Now, my lord, we have filed one application for leave to prefer appeal, since that judgment is, my lord,
Affecting your rights.
yes, and my lord, another judgment is in our favor. So this is qualification of, my lord, physical education teacher. So my lord, we are qualified, we are TET qualified, but interviewed, but appointments are stalled. So my lord, your lordship, kindly do one thing, my lord, subject to your lordship. I am not standing in the way on their prayer for adjournment. Only thing that your lordship, kindly allow the condonation application. Delay is there. So my lord, that can be done, Lord.
Take it up on that.
Delay of how many days? Delay of how many days?
Lord, there are two appeals. In one appeal, Lord, 114 days, and in another appeal, 250 days.
After vacation.
After vacation, Lordship.
Okay. After vacation.
16th June.
Yes.
But at 2 p.m., Lord. Otherwise, Lord. 16th ki bharat.
Hmm? 17th 2 p.m. 17th 2 p.m.
Lord, Lord, can it be on 15th, Lord, instead of 17th?
We have fixed, madam. You have problem on 17th?
17th, I have some problem, Lord. Any day, Lord, any Monday or Tuesday, Lord.
Or 23rd 2 p.m. 23rd আছে কিছু? 24th? 24th 2 p.m.
I'm extremely grateful to my Lord. Extremely grateful.
Both, no? 7 and 8.
7, 8. Same order is impugned, Lord. Same order.
Yes.
Four, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 29, 30, 31, 2, 33, 34, 36, 39, 40, 41, 42, 43, 44, 45, 46, 47,
47, my lord, I appear for the petition. kindly
takes
up the matter after vacation. Kindly then, my lord, in that event, my lord, I appear for the petitioner, my lord. This is, my lord, in regard to, my lord, the pay scale fixation. My lord, kindly, my lord, fixes it any day after the vacation if whatever my learned friend, you are appearing for the
After
ISI
vacation,
or lord, we
let it be in the list, next monthly list. When it is called on, you mention before. Yes.
my lord,
It, Mr. It cannot be fixed just now.
I appreciate.
Come after the vacation, when it is called on, you remind us, we will consider.
I will. Great.
9, 15, 1, 53, 55,
56, I appear for the appellant. Well, in this matter,
Next
also-
one.
57, 58, 61, 61. Okay. 64, 65, 66, 7, 68, 69, 70, 71, 70, 73, 74.
लिख देता हूँ।